All right, I see we have some participants coming in, so welcome everybody, and we're just gonna give it a minute and then we're gonna get started here. So thanks everyone for joining. All right, so it looks like it's 1:31, so we're going to go ahead and get started. Thanks everyone for joining. My name is David Yulian, and we're with Vicente, and we're going to be presenting on major statutory and regulatory changes in Massachusetts, what current and prospective cannabis operators need to know. Just a bit of housekeeping. This webinar is going to be recorded, and will be available via email. And if you have any questions, please drop them in the Q&A chat, and we'll try to answer as many of them as we can if we have time at the end. So let's go ahead and get into it. We have a lot to cover. So next slide, please. It's a little bit about us. We're Vicente LLP, cannabis and psychedelics law firm, started in 2010 and help represent clients with a variety of legal and compliance issues in the cannabis, hemp, and psychedelics industries. We have offices around the country and provide a variety of full service legal services, including licensing, corporate, litigation, transactional, intellectual property, and more. Next slide. So today I'm joined here by my colleagues Sally Peebles, Casey Lever, and Phil Silverman. They'll introduce themselves when they get to their sections, but great group of people joining here today. Next slide. So just an overview of where we're going to present today. We'll go over the new cannabis reform statute that was recently enacted. We'll cover some of the new cannabis regulations, including social consumption establishments that went into effect over the last few months. We're going to do a bit of a deep dive into social consumption establishments and discuss real estate, site control, local approval considerations, as well as compliance and operational requirements. Next slide. So initially, this presentation was going to focus solely on new regulations in Massachusetts, but since the time we scheduled this, there was a new cannabis reform statute that went into effect. And even more recently, as many of you know, we have rescheduling. So we're going to try to touch on the cannabis reform statute, but the primary focus is going to be on the social consumption regulations. But well, next slide, please. So the new statute that went into effect, it's H5350, an act modernizing the Commonwealth's cannabis laws. It was a version was initially passed by the House, a different version was passed by the Senate, and then there was a legislative conference committee that came together to reconcile the differences. And Chapter 65 of the Acts of 2026, that's the formal name of the law, was signed into law by the governor on April 19th, and it was an emergency law that went into effect immediately. So almost all the provisions went into effect except for the provisions regarding delinquent licensees, which we'll touch upon in a little bit. Next slide. So some of the key changes under the new statute, so the Cannabis Control Commission is restructured, reduced from 5 commissioners to 3 that are all being appointed by the governor. That has not yet occurred yet, so currently there are no commissioners, and we hope those will be appointed by the governor soon. One of the major changes is increasing the retailer license cap. It used to be a maximum of 3 that a person or entity could hold. That has now increased to 6. But there is a bit of a phased rollout for that. So for the first year after the law goes into effect, there's going to be only social equity businesses will be allowed to hold 6 retailer licenses. And then after that 12-month period, all types of licensees will be able to hold 6 retailer licenses. Almost as important is the increase in the equity ownership thresholds for what constitutes control. So it used to be 10%, that has increased to 20%. There's also new provisions about delinquent licensees, which will prevent certain licensees who owe a debt for the purchase of product for more than 60 days. They will be added to a delinquent list that will be publicly accessible, and if you're on that list, you will not be able to purchase or have product delivered except upon full payment on or before delivery. So this is a major change that's fashioned after the alcohol industry, but it does not kick in until 2028. So a bit of a time to get ready for that, but that will be a significant new provision that a lot of operators are going to have to realize, figure out how to navigate. Another major issue is vertical integration for medical is eliminated. So since the beginning of the medical program, all medical licensees had to be vertically integrated, which means they had to grow, manufacture, and sell their own product. So that is no longer the case. Now, going forward, you can be a vertically integrated medical operator, but you do not have to be. And you'll be able to apply for separate licenses. So, for example, a separate dispensing medical marijuana establishment license that will allow you to sell medical cannabis without also having to cultivate and manufacture. But there is an exclusivity period for the first 2 years. For any new licenses just for medical will only be available for social equity businesses. And with rescheduling now, this is a particularly interesting new aspect of Massachusetts because 280E goes away for medical cannabis businesses. So I think there'll be a lot more interest in medical licenses since that tax treatment has really changed under this new rescheduling order that was released today and is going to have major impacts on the industry. Another major change is increased purchase and public possession limits from 1 ounce to 2 ounces of cannabis flower or the equivalent of marijuana products. And as you may have seen, that already has gone into effect and was something that could be purchased up to 2 ounces already in advance of the 420 holiday. So major changes we're already seeing in the mass market for purchase limits. Next slide. Home delivery. So now home delivery will be allowed in every municipality in the Commonwealth unless the municipality opts out of having home delivery and requests a waiver from that requirement from the commission. And if that waiver is granted, it would only be for 2 years at a time, at which point the municipality would have to request an extension of that opted out delivery. So expanded home delivery across the state now, which is great. New advertising rules for retail establishments. Now they will be able to advertise discounts and loyalty programs in store as well as via email opt-in. So excellent new rules to enable more marketing and advertising for retailers. The commission is going to establish an online portal for anonymous reporting of alleged regulatory violations. There's already a way to submit anonymous tips, but now the commission is going to create a portal for it. So should be interesting to see what types of anonymous tips are submitted there, but something to be aware of for operators. Seeds are no longer included in the definition of marijuana under state law. So theoretically, that could mean that you could buy seeds at, Whole Foods or Home Depot, just like, flower seeds or tomato seeds. So interesting to see how that might be impacted. And but there is a change in federal law as well that's coming in November of this year that would have an impact on the ability to buy seeds and whether those would be considered hemp or cannabis now. So something to keep an eye on as we get closer to the end of the year. And then with respect to hemp, there was some discussion about putting in a comprehensive regulatory framework under the House version of the bill, but when the conference committee reconciled the differences, they decided to sort of punt that and require the commission to develop a study and recommendations for regulating hemp-derived products. So we should know more on what the commission comes up with on what their recommendations are for regulating intoxicating hemp-derived cannabinoid products later this year. Next slide. So just a bit of the timeline here. As I mentioned, this was an emergency law that went into effect immediately upon the governor's signature on April 19th. Almost immediately, the commission started issuing certain bulletins and administrative orders to try to implement the new law in advance of formal rulemaking. So you may have seen some bulletins or administrative orders regarding purchase limits, as well as municipal, restrictions on delivery. So that's something to keep an eye on. Although the commission is in a bit of a transition period, there are some regulatory developments to be aware of, and to be on the lookout for, while the commission starts to promulgate formal regulations to implement the new law. Something to be aware of is that with regard to the additional retailer licenses, the commission is required by the law to start accepting additional retailer license applications within 2 months of the effective date. So under this new law, by June, we should be able to start applying for new licenses above the cap. So again, something to keep an eye on, but would be good to start thinking about expanding or acquiring new licenses, if that's something that you're interested in doing. The default is for the commission to implement regulations fully implementing the new statute, whether that be creating new regulations or amending the existing regulations within 1 year. And as I mentioned, the delinquent licensee provisions do not go into effect until January of 2028. So a bit of a lag time there, but definitely something to be ready for when that does go into effect. Next slide. All right, so that was the new cannabis reform statute, and now we'll turn back to what we initially wanted to talk about on this webinar, which was the new regulations that have gone into effect over the last 6 months. So primarily the new regulations relate to social consumption establishments, but it's important to be aware that there are other regulations impacting all sorts of license operations, including a streamlined badging process for agents so that instead of having to have a separate badge for every type of license, for every type of operation in a facility, you can now have one agent badge that would cover all of the different licenses that are owned by the same company with the same owners and people in control. So a streamlined process that the commission is going to roll out, which should really help to minimize additional cost and administrative hassle. Retail stores are now able to sell non-infused, shelf-stable food and drinks. So, whereas that was not allowed previously, now retailers and delivery operators can sell, things like bags of chips and water and drinks, things that people certainly would want to have for, the later on in their consumption sessions, which is great, and an additional revenue source for operators. The delivery period for the exclusivity period for delivery companies has been extended. That's something that the commission has the authority to do, and they did vote to extend that now to April of 2029. It's possible they could extend it again, but for now, only social equity businesses are able to apply for and operate delivery couriers and delivery operator businesses at least through April of 2029. And then just also wanted to mention that the commission revised their secret shopper program. There is an opportunity for people who want to participate as third parties in the secret shopper program. They can also apply to participate in that. Next slide, please. All right, now we're going to focus on social consumption establishments specifically. Next slide. So social consumption establishments have been contemplated in Massachusetts since ballot question 4 legalizing adult use was approved by the voters in 2016. It was initially envisioned as a pilot program for a limited number of municipalities to opt into, to sort of see how it goes and allow this license type to be tested out. But eventually, the commission changed that and made it aligned with the other license types that you could just apply for and roll out. There was a legislative fix that was required. It was a bit of an oversight on the legislature's part, but they fixed that to allow municipalities to opt in to having social consumption establishments within their borders. And although it's been almost 10 years, there are still no licensed social consumption establishments in Massachusetts, which is unfortunate, but now we're at the time when they're starting to really roll this out. So we are looking forward to finally having these get up and running. Next slide. So social consumption establishments. So generally speaking, these are license types that allow for cannabis and cannabis products to be sold to adult use consumers and consumed on site in designated areas of the licensed premises. There are three different types of social consumption establishment licenses, which are supplemental, hospitality, and event organizer. And there are four different types of consumption areas. So indoor and outdoor smoking and indoor and outdoor non-smoking. So a couple different options here depending on what type of facility and experience you want to offer your consumers. So a lot of options here. And I think it's, we got to tip our hat to the commission and the legislature for making this a very expansive license type. It's certainly more of room for creativity and options than we see in some other states where the license type is a little bit more limited. Next slide. So social consumption establishments, the supplemental license types. So this allows for sale and consumption within a designated area of an existing licensee's premises. So you have to be an existing licensee, and there are a number of different license types that could take advantage of this. So retailers, cultivators, manufacturers, micro businesses, craft marijuana cooperatives, third-party transporters, delivery operators, and couriers. So almost all of the existing license types are eligible to apply for a supplemental social consumption establishment. And obviously it'll depend on, the type of facility you have to see what type of social consumption establishment makes sense. But those are the eligible licensees that could apply for this license type. Next slide. So hospitality allows a licensee to establish a new business or operate within a non-cannabis entity to sell and permit consumption in a designated area. So this is what I think most people would have thought of for social consumption establishments that you might see in Amsterdam or in California, where it's more of like a cafe type of situation. But it really could take a variety of forms, and the sky's the limit in terms of what you might want to come up with. So a couple that come to mind might be like a cafe or a yoga studio or a movie theater or a bed and breakfast. But it really, there's not limited to any specific venue. And so this is a license type that I think will be attractive to a lot of people who have a very unique idea about, how these things will operate. Next slide. And then finally, there's the event organizer licensee. So this allows the social consumption licensee to coordinate temporary consumption events. You have to come up with an event plan that has to be submitted to the commission for approval, and you're limited to no more than 30 single days of events per municipality each year. And again, this could also take a variety of versions, but I'm thinking of things like an outdoor music festival, or maybe a wedding, or some sort of conference event. So you think of it more as a temporary event where you can have vendors come in and offering to sell in an area where you consume, but it's not a permanent facility, and it would really be scheduled around a particular type of event that's already happening. Next slide. So there is an exclusivity period similar to delivery. For an initial 36-month period, social consumption licenses will only be available for businesses that are controlled and majority owned by commission certified economic empowerment priority applicants or social equity program participants, as well as micro businesses and craft marijuana cooperatives. And this exclusivity period will end when at least one social consumption licensee in each of the three categories is granted authorization to commence operations by the commission. And as we've seen with delivery, this exclusivity period could be extended depending on if the commission determines that it's necessary to allow, certain types of applicants to participate. So we could very well see that exclusivity period extended. So if you are one of these types of applicants or businesses, this is a very unique opportunity that you can take advantage of. But if you're not, there's still an opportunity to partner with an eligible applicant to be involved in this type of business, as long as you structure the ownership and control correctly. Next slide. And then lastly, ownership and control. So similar to other license types, except for retailers now, you can now you can now hold or have direct or indirect control of up to 3 social consumption establishment licenses of each of the 3 license types. So very similar to the sort of, 3 license cap we see with almost all the other license types except for retailers now. There's also some unique ownership and control restrictions for hospitality and event organizer licensees specifically that restrict the types of compensation or payment arrangements that you can have with the entity or the venue that's hosting or housing you. And Sally will get into that a little bit later, but just note that there are some restrictions that will prevent certain types of payment arrangements or lease payment arrangements that you may not expect with other certain license types. Next slide. All right, and I will now kick it over to Sally to focus a little bit more on some of the real estate and site control considerations.
Hey guys, my name is Sally Peebles. I've been focused on pretty much nothing but real estate and cannabis and psychedelics for about 12 years. Um, and excited to talk about some real estate considerations around social consumption. So, if you are interested in doing this or you're helping someone do this, there is a process you should follow. The first thing you're going to want to do is work with the municipality, the city that you want to be in, and make sure they've actually opted in to allow this license type. Um, I've worked with a lot of licensees every year that find a fabulous location, but the locals don't allow it. So that's going to be step one. After that, you're going to need to work with the municipality to make sure that the property you are looking at is compliant with zoning and setbacks. The setback the state sets is 500 feet from schools being defined as K through 12. But sometimes the local municipalities like to get their hands into regulating the time, place, and manner of these things when it comes to setbacks. And if they do, you just want to make sure that they're not making things more restrictive, having a different front foot, or identifying different sensitive uses. They could add churches or certain other sensitive uses to the setback. I always recommend, if you're looking at a property, to send it to us and we'll help vet it. We have a licensing team that can really take steps to make sure that what you're looking at is a good spot to do your desired use. And then, you're going to want to approach that landlord or seller if you're looking to buy. Generally, most of my clients are leasing because there's a lot of capital needed to buy properties. But if you're able to buy the property, great. You're going to need to be able to show that purchase agreement, or if you've already closed, in that deed to the regulators to show that you have possession of the property. Otherwise, you can also use a binding LOI, letter of intent, or a lease to apply with. And we'll chat a little bit about what lease terms you want to consider. And a lot of these you could also include in the purchase agreements to protect yourself. Next slide, please. So I'm going to go over just a few high-level lease terms that you want to start talking to. I mean, if you want to bring in Vicente at the point when you're talking to the landlord or talking to the seller, I do recommend that, because then we can really make sure that all the material terms are laid out in an LOI early on, so there's no surprises later. But if you're the one negotiating, or you're a bit more of a go-getter and want to do this yourself, these are the topics you're going to want to make sure are covered. Let me pull this up a little bit bigger. Okay. So first, you're going to want to make it that you are able to assign this lease or assign the purchase agreement without that approval. You can often talk to the landlord or the seller and say, hey, we may need to restructure. Cannabis is a very unique license type. You want to be able to be allowed to have a merger or a restructure, or maybe even have a lender.
Did we lose Sally? Sally, can you hear us? Okay. All right. I will jump in, or Phil, do you want to jump in here and hopefully we can get Sally back?
Sure. Do you want me to start the municipal and then we'll go back?
Sure.
All right. Why don't we do that? Gia, if you want to turn ahead a couple of slides. Fantastic. Um, Everybody, my name is Phil Silverman. I've been an attorney for, gosh, almost 40 years now in Massachusetts. Had a 30-year career as a bankruptcy lawyer in Massachusetts. I still do a little bit about it. Hopefully, none of you ever need that kind of service. Now, what I do mostly is municipal work. We do things like trying to work with cities and towns to create favorable zoning for your business. We negotiate host community agreements. For those of you that may not be as familiar with the industry, I'll explain what that is a little bit later on. We also do local permitting, site plan reviews and special permits to get your business up and running in the community. So, those are the types of things I do. So let's start with a broad overview in terms of the municipal process. This is what's called an opt-in statute for social consumption. In other words, if you remember what happened when retail marijuana rolled out in Massachusetts, basically it was legal, and if you wanted your community, if the community didn't want to be a part of that, didn't want to have, for example, a retail store, they had to, go about actually having, in many cases, a town vote to prohibit that type of activity. A little different here. Here, it's basically the only way your community is going to allow it is if they opt in to social consumption. So, that's a bit of a higher burden, I expect that to be something in some ways maybe more controversial than trying to get municipalities to allow retail establishments. I think there's just going to be, at least initially, a little hesitance by the community to allow social consumption. But I think the key here in all of this is if you're really interested in this type of a business, it's really going to be on you in a lot of ways to get that community on board. Okay. A lot of them don't even know about this right now. They don't know that these regulations just came into effect. They don't know what the process is. And so I think, it's up to you in some cases to go to the town administrator, if it's a town, or somebody in the city council or a mayor, and just say, I'm interested in this, what do you think? And certainly we can assist you with that. But sort of part of that also, in addition to this sort of opt-in where presumably the town is going to have to notify the state, yes, we're in, is going to be creating the zoning that allows for this. And I think you want to be a part of that too, because there's going to be a tendency, as there always is in cannabis, for local communities to overregulate this and just create obstacles that don't need to be there. I think, you want to go in at the beginning and try to convince the community that they really should be sticking with the state regulations and that they really don't need to go further than that. The state regulations are, going to create some hurdles themselves, but we don't need additional things, and we see them all over time. You see, for example, in the retail side, there's a 500-foot buffer between a retail store and schools K through 12. It used to be a lot worse. The 500-foot buffer used to also include churches and playgrounds and the phrase was places where children commonly congregate. If they try to put those types of restrictions into the zoning here, it's a real problem. It's probably illegal to do that because it would conflict with state law, I think, but you don't want to get into a situation where you're litigating issues before you're even open. So I think you want to go in and help shape the zoning as things are proceeding in order to get your town to sort of allow this to happen under really the state guidelines as opposed to any other local requirements. So the next step, let's assume you get your zoning in place the way you want it, is you're going to go to the town and you're going to have to do a host community agreement. This is the agreement that sort of lays out responsibilities and duties between the town and the operator. And again, these were things that became very complicated at the beginning of marijuana legalization. It's simplified a lot now because the Cannabis Control Commission has a template HCA form that's really not all that burdensome, and a lot of towns are adopting it. Some still require their own forms, as long as they comply with the CCC's rules. But a lot just allow this simple template. And again, hopefully we can convince towns that that's the better route to go here. But you're going to need to negotiate a couple terms with that. Again, like Sally was talking with real estate, is this assignable? Do we need their permission? And a whole host of other things. But it's not all that complicated because the template's pretty simple. After that, the next step is going to be the community outreach meeting. In order to get a state license, you need that HCA, but you also need to conduct what's called a community outreach meeting. Now, there's nothing, you're basically meeting with the community and you're telling them about the project and you're answering questions. And there's nothing that can sort of come up there that stops the process for you. They don't get to vote at the meeting and say, no, we don't want you. It's really just intended to be an information session, but it can be a situation where people who are against this are galvanized. And so there's some strategies for the timing on when you hold those and, what you want to be saying at those meetings that I think is really going to be important here. I expect, just like we saw at the beginning of retail stores coming out, that people in the community are going to show up. Not all of them are going to be supportive. And, you're going to have to explain this. I have no doubt that in the end, just as has happened in retail, people will begin to accept this. People will understand that it's not going to be a problem in the community. But it's going to take, some intelligent discussion and disclosure of how it works for people to get that this is going to be okay, and we're going to do it cooperatively with the community. So that meeting is going to be an important piece of that. After that, again, depending upon how the zoning is drafted, most communities are probably going to require to have what's called a special permit in order to operate this, and site plan review. So this is going to, require, potentially civil engineering plans, site plans, floor plans from an architect. They may require traffic studies. They may concern themselves with what your standard operating procedures are, odor issues. There's a lot of topics that they can cover here to make sure that this is going to be done in a way that doesn't harm the community. I would tell you, if you're looking to do this, you want to get a good head start once you find your property on getting these types of plans done. Architects and civil engineers are very busy, and they can often take weeks and months to put these things together. So, what we're looking at here, when you add it all up between the zoning, which I think is going to take anywhere from 6 to 8 months in a lot of cases to get put in place, and then you're looking at the lead time that you need for these plans to get drawn up and applications drafted for special permits and site plan review. There's a lot of time here, and you want to kind of do things as quickly, have everything ready so that the moment you become eligible to file a particular application, you can file it. You're not just waiting for people to do sort of administrative procedures associated with it. So, again, there's really no substitute for starting early with all of this. The last thing I'll mention, some cities and towns have additional local license that you might have to apply for, or an operating permit. These are generally not as burdensome. It's just kind of paperwork in a lot of cases. We can certainly help you with that. So all in all, the message, I've said it a bunch of times, get moving early if you want to do this, especially in terms of contacting the local community. Really right now is the time to do that, because that's going to start the whole process. Always here to help you with any kind of questions you have about this, and look forward to working with you too. So that's it for me.
All right. Casey Lever, I'm the Senior Director of Regulatory Compliance for Vicente. I work with licensees to go from a piece of paper to operational, helping with enforcement action. And, everything from preventing you from getting it to responding when it happens and doing routine audits. So I've seen a lot of things, but at this point in Massachusetts, haven't seen social consumption. So I'm looking forward to it. This, just a fair warning, is not a comprehensive overview of all of the possible compliance and operational things we need to consider here with these licenses. Personally, I think it would be good to do maybe a webinar by license type, because just, the event organizer license alone has some pretty robust requirements and some interesting things to think about. The regs generally for social consumption are, for lack of a better term, like extremely robust in a way that is, in some places, provides flexibility, and in others, it contradicts existing parts of the regulations, and even within the social consumption requirements, I think there's some contradictions. So that said, let's get into some of the high level, big takeaways that you should be aware of when you're planning out these type of businesses and planning to work with them. And typically compliance is doom and gloom, and I'm the no person. So I'm going to start with like what's allowed for social consumption establishments. I thought this was an interesting concept that we're going to see in social consumption that we obviously have not seen yet, is the ability to portion servings of products to consumers. Social consumption licensees, any license type, can white label, repackage, transfer waste, wholesale, and warehouse. That it applies to all social consumption establishments. The other thing I want to note real quick is social consumption establishments are marijuana establishments. So as we're pinpointing some of the social consumption regulations, it's important to note that you will be a marijuana establishment as well. So security requirements are generally going to apply, visitor logs, things that aren't specific to your type of operation, but are generally required of all marijuana establishments. All right, that's enough of my CYA probably. All right, so for sales, right? You're able to sell shelf-stable products, so prepackaged food, water, things like that. You're permitted to sell or have delivered outside food, which would be a cool concept to see, hopefully, and play out in different manner. It gives you some flexibility on, I imagine, like somebody literally sitting at a cafe having DoorDash delivered, and consuming their food right there. There are some point of sale limitations, but they aren't too crazy. And now with the actual possession limits increased, the restriction is you can't serve to a consumer at one time more than half the legal limit. But again, that has gone up, so not so bad. Open tabs are permitted. I'm calling it a tab, but think of it like a bar where you leave your tab open. Something addressed in regulation, which is interesting. The social consumption establishments may repackage or portion servings, which I mentioned before. And that includes edibles, beverage, tinctures into single or multiple serving sizes for sale or service to customers, provided, of course, that the individual serving size complies with the serving size limitations and the potency limitations. That is one that I think is super creative and gives a lot of space for licensees to come up with different ways to serve their customers on site. I think that that's actually a more positive regulation, but something to be aware of as you're trying to be creative about how you want to go about operationalizing social consumption establishment. Next slide. All right. So let's talk about signage and consumer information generally. I tried to break these up into categories, but honestly, there's so many regulations that some of these might overlap. So there's a required use of what they're calling an automatic identification technology, or AIT, to link to COAs. Layman's term, it's a QR code. It's technology. They say QR code or an RFID tag that essentially allows consumers to, without manual entry, scan, tap, or interact with a code tag or similar marker to obtain information. It is required, right, to link to COAs. So that will be an interesting technology, and I'm not sure if that's something that, operators will lean on, like a retail ID from Metric, or how that technology is going to function, but something to think about. That is on the licensee to figure out how to comply with that one. You're also required to display a consumer information card that includes, kind of the almost basic consumer safety requirements, a warning. It can be used and so can the QR to be used to provide labeling information, menu information, things like that. But there's also a requirement that an insert menu label or QR has to go with products that provide a specific warning as well. It's a specific warning, it's the amount of time for the onset effects, and it's access to the COA. So we do have varying requirements on information that must get to consumers. What seems to be the fastest way to do it is we're leaning on technology for the first time in some of these, the regulations here for this particular license type. So that's definitely playing in your favor. You have to have clear boundaries and signage for consumption areas. Those clear boundaries and the premises, which we're going to get to next, is going to be something that is also something that's be very important in the planning phase from your floor plans and when you do your event plan, figuring out where your premises is. It's important now for any operational licensee, but it is going to be extremely important for social consumption, particularly because you are responsible for what goes on in your premises and what can and cannot be done on your licensed premises. There's limitations on the hours of operation. You can only occur between 7 a.m. and 12 a.m. and you have to stop 30 minutes prior to the latest time the licensee is authorized to conduct sales. That, when you're authorized to conduct sales, can obviously vary by municipality, event plan, etc. What I think is really interesting in the last one of the requirements here is that an ID scanner must be used for age verification. No other licensee, and this is something I brought up during the, comment period, was a retailer isn't explicitly required to use an electronic ID scanner, but social consumption establishment licensees are. So that includes, the event licensees. So you're out at an event, think about, you're going to have Wi-Fi or whatever's needed to connect those handheld scanners. Next slide. Like I said, the premise is going to be huge. There is so much that we're going to get into about the separation of the sales and service areas versus the consumption areas. So first of all, there's no alcohol or tobacco consumption or sales allowed on site. There are some caveats in the regs that talk about what happens if you have an adjoining wall, right? Like let's say, I'm right next to a bar, right? I'm not in the same space, but what does that mean? So the regulations do address that in some manner or fashion, but again, that's a deep dive and happy to answer any other questions on that separately. Separation of products purchased at retail. The regs are pretty specific that you can't take what you purchase at retail and bring it to the consumption. It needs to be purchased separately, which I think if you are somebody who's going to be connecting a retail establishment to a social consumption area, we should probably think about what that looks like for you in particular, and if there's any leeway in making that function better for you. Again, the separation from the sales and service area and the consumption area, it's very clear there needs to be a secure door, and secure door is defined a little differently. There needs to be sales areas at marijuana events, and for marijuana events, there actually needs to be an indoor sales area, which in the regs, they contemplate some sort of a trailer to accomplish that. And there needs to be separation by an enclosed space of the sales, again, in the consumption areas. You also need to have access to toilet facilities, no matter what type of social consumption establishment you are. And there are very specific ventilation and odor control requirements for indoor smoking areas. They're very specific, they're cumbersome, they're ultimately going to be extremely costly. But these are things, again, keep in mind when you're vetting spaces, when you're coming up with plans, when you're kind of, determining which license type you're going to go for. And then there are warehouse operations permitted for event organizers. However, there are specific requirements for the warehouse, which include that you have to have a sally port or a loading area adjacent to the warehouse that enables the transfer, essentially, to pick up cannabis to bring to the event. All right, next slide before I take up all the time here. Do my best. Again, I could talk about this one for days. Okay, day-to-day operations. You're required to have PPE for employees of smoking consumption areas. That should be no surprise. You need to make it available. They need to be able to wear it if they need to. That, again, safety, number one. Now, the monitoring of consumption areas, this is where we have our overarching security requirements, right, with cameras in areas where cannabis is handled, etc. However, there are some caveats here for social consumption. For smoking areas, the visibility of the smoking area can be observed via natural sight through marijuana establishment agents, through windows, or via CCTV. That's unique to these establishments, and I imagine it might have been due to pushback on enjoying yourself in a consumption space. For the supplemental and hospitality on-site consumption area, you have to have the unobstructed camera coverage. So a little bit different based on the type of consumption there. And then for marijuana event organizers, the language is even slightly different, where you have to, at minimum, provide camera coverage for all sales areas. So how that's going to play out is largely going to be based on your event plan, where it's going to be, how you plan on doing any sort of, enclosed space for your sales area, and what the actual consumption space looks like. But this provides a lot of flexibility. This may change the cost associated with doing some of these events and how fast things can be put together and pulled back down, especially on the marijuana event organizers. Now, there are waste disposal requirements that are unique to social consumption, but seemingly kind of common sense in my mind. You have to have locked receptacles, waste receptacles in the consumption area. And if it's going to be any smoking, any vaporizing, or any combustion or heat is used to consume, the waste receptacles have to be fireproof. The receptacles have to be checked at the end of each day. They have to actually not only have to be emptied at the end of each day, everything actually needs to be disposed of. That's unique to this license type. You don't have to dispose of your waste every day in the retail environment, cultivation or manufacturing, but social consumption, every day, emptied and destroyed. And that's at minimum. If the receptacle gets full, you're also responsible for emptying it then. And last, some other notable provisions I'm trying to squeeze in here is agents cannot infuse or combine marijuana with food or drink. However, a consumer can. So that gives us a lot of creativity in how, again, these individual servings are going to be sold and what happens with the consumer interaction. Consumption of outside products is not permitted, so I can't, bring from one dispensary something in to consume at your consumption space. And you cannot allow, encourage, or permit any organized game or contest involving competitive or cooperative consumption of marijuana or marijuana products, or awarding of marijuana products as a prize. The second part, awarding marijuana products, common sense, but no games, no fun contests at any social consumption sites. All right, I tried to squeeze in what I could.
All right. Thanks, Casey.
Yeah.
And so I don't think we'll have time to go back and cover all the real estate slides, and apologies for the technical difficulties, but the real estate portion is certainly an important part of this. You need a property that is going to work, it's zoned correctly, you need documentation that shows you have a binding interest that will allow you to apply for a license, but gives you the flexibility to get out of it if you aren't able to get all your licenses and permits, or assign it if you eventually want to get out. So that's a very, very important piece of it, and certainly, take the time and think through it before you bind yourself in any way to lease or buy a property. But again, happy to help you navigate those issues if you need assistance with that. And before we get into the Q&A, we just wanted to mention that as we start to get ready for the licensing process, top 3 tips that come to mind are just to understand what the requirements are for the different license types. Start early. This is a long process from start to finish, and especially with a new license type that is rolling out for the first time, there's going to be some confusion both at the commission level and at the municipal level. And finding property can always be difficult. Lining up your financing can be difficult. So start this process early if this is something you really want to do. And then make sure you review all of your application requirements and your documents so that you can really navigate and work through the licensing and permitting and inspections process quickly and efficiently and get up and running as soon as you can. And again, we've been doing this since the medical program started, back in 2013, and we've worked with dozens of different types of applicants in different jurisdictions and areas of the state. So, we're here to help you and work with you as you try to work through this as well. Before we just have a couple minutes, I'll try to look at some of the questions here. There was a question in the chat, is for a medical license in Mass, is it still social equity only? So under the new statute, there will be separate types of medical licenses available. Like I said, if you just want to do medical dispensing, that'll be a specific type of medical marijuana establishment license you can apply for. But under the new statute, for any new applicants for medical license, it is exclusively going to be for social equity applicants for the first 2 years. So that has not been a requirement up until now, but going forward for the first 2 years for this new medical licensing, they will only be available for social equity applicants. There's a question about the question is, do you think social consumption will be a by right land use in any zoning districts, i.e. no special permit requirement? So, this is a very new license type. I think there's a lot of concerns that municipalities will have about public safety and public health. So I would be shocked if this is a use that is allowed by right in any zoning districts. I guess it's possible, but I would not expect that. But I don't know, Phil, if you have any thoughts on that particular issue as it relates to the municipal piece.
Sorry, I'm having a trouble. Oh, there we go. If you want that to happen, I would go start speaking to somebody now, because the tendency, I think, is going to be to think that can't happen. That there's going to have to be a special permit involved. And, we could talk about with these communities about something short of that, where, maybe it's just site plan review, or maybe there's just some regulations that they pass regarding how these operate, but without having to go through a whole special permit process. But yeah, like you, David, I think they're going to require it.
Yeah, I agree. I mean, these days, any type of cannabis use typically requires special permit and site plan review. There may be some, very accommodating municipalities for certain license types that might not require it. But again, I think that would be a pretty rare occurrence. So I would go into it expecting to obtain a special permit and site plan review approval for that use. Question, can you explain exclusivity in more detail in the timeline with the initial licensure? So assuming you mean exclusivity for social consumption establishments, under the rules, there will be a 36-month exclusivity period for social consumption establishments, such that during that period, the only types of applicants who can apply for social consumption establishment licenses are social equity businesses, micro businesses, and craft marijuana cooperatives. So during that exclusivity period, those are the only types of people who can apply for and obtain those licenses. Now, the exclusivity period ends when there is at least one type of each of the 3 social consumption establishments that has authorization to commence operations. So once the commission approves one of each type of social consumption establishments to operate, that is when the exclusivity period technically ends. But again, this could be extended by the commission if they do an analysis and determine that they think it should be extended to give those unique applicant types more time to break into this special type of new cannabis business. They may extend it, and then, like we saw with delivery, that is something that has happened. So again, 3-year initial exclusivity, but could very well be extended. Let's see here. Will establishments be able to order food or only pre-packaged? So, So certainly social consumption establishments, in fact, I believe they're required to offer food and water to consumers at the establishment. But I believe there will be an opportunity for them to serve food at the establishment, but that only can happen if they obtain all the necessary, state and local licenses to be a food establishment. There are certainly licensing and permitting requirements for a business to make and serve food, both at the state level and at the local level. So, we would certainly want to make sure you obtain all of those approvals before you do so. But my sense is that the commission does want to try to make these businesses as open and available to serve all sorts of different types of people and food, and make different types of environments that people can really enjoy while they're there. So I do think food is going to be a very central part of that. But again, got to make sure that it's approved, by the necessary regulators, which are not just the Cannabis Control Commission. And let's see. Believe there was a question about doing a joint venture for an existing rec dispensary with a social equity controlling member to apply for a medical retail license before the exclusivity window ends. So I'm not sure I totally follow that, but I do think there is an opportunity to change your structure to be a social equity business. And if you're a social equity business that qualifies, you can apply for a medical license during that exclusivity period. So you'd want to make sure that any joint venture with an existing licensee goes through the change of ownership and control process, and that you're not violating any license cap issues. So the commission would need to approve any sort of change of control if you're trying to bring in a new partner. But if you are majority owned and controlled by a certified social equity applicant, that should qualify you to obtain that medical license once the new medical licensing rolls out for these license types. But again, want to be careful there to make sure you don't inadvertently make yourself ineligible or violate any regs along the way in order to try to make yourself eligible for that license type. So again, happy to help you work through those issues, but it should be possible. So we're out of time now, but thank you so much for everyone who joined. You'll see here we have our email addresses here. You'll also be able to find us on our website. But so feel free to reach out. And again, we're looking forward to this. We've got a lot of experience doing this, and we're happy to try to help you through it. And so I would keep your eyes and ears open over the next, 6-12 months as municipalities start to opt in. But start thinking about what type of license you might want to operate, where you might want to be, and lining up your property, your team, your financing, and just put yourself in the best position to take advantage of this during that exclusivity period. Again, thanks everyone for joining, and we appreciate it.